dropping in. I just want to ask Tom a question or two.
What's your name?
William Montgomery?
Okay.
Thanks. Greetings. Long time no see. My beard just gets
more and more impressive.
I can't shave it down. I'm too invested.
I like this. I have to walk over to the courthouse. You want to accompany me?
Yeah, absolutely.
I saw that you lost the trial.
Oh, indeed. The whole idea of going pro se is actually still doing exactly what I had intended it to be, which is there's a very big problem in this country where people don't respect pro se attorneys. So whenever they say things like you're saying, now you can't take one ear out the other. So there's no basically everyone judging it for the purposes of trying to push or guarantee a lawyer. They only want to deal with lawyers and stuff like that.
Well, I also find that certainly when it comes to, well, from what I can see of your case, as an outside observer, there were two things you did that probably did more to ensure your downfall than the other circumstances. I had inferred that you felt after convicted going to be successful.
Yeah, that's true.
So, I don't know if I just want to talk about that, but, we've known each other for over a year now. The fact that you've been in a number of cases where the city stops or whatever, it basically, hustling, question shots on you and other folks. Disproportionate opinion of your ability to try case against guys with very skilled felony attorney on case as well.
Sure.
It's called the Thomas that he tried to do. I think
Well,
Thomas not even speaking yes.
yeah, well, when it came down to it, basically all the elements were kind of stretched in a few. And there was actually a lot of disputed facts that never got resolved, even though I kind of pointed them out and I said, yeah, like I said, jobs instead of jobs. So they never actually got out. And they basically washed over any disputes I had.
The other mistake was that, there was a tremendous mistake. Was the way you
Oh man, well I got wrong for convicting a jury before. I don't trust juries with their lack of instructions properly bad. Plus I kind of wanted to take it out a bad judge. And so the whole point is that I actually feel like I at least got all of the evidence necessary and the facts and the disputes law for a competent appeal. And so my problem is that I literally don't have enough time anymore and to put that kind of thing in. And so this is the point where I officially have to decide that I'm going to have to delegate out to attorneys. And so I was kind of wondering if you wanted to help out possibly quote to see if
I don't do any appeals.
You don't do appeals?
I don't do appeals. I'm doing one appeal now, and boy, it's a pain in the ass.
Yeah, it is, yeah.
So
you gotta sort through a lot of crap.
Well, I just don't know what I'm doing. I mean, it's not like when I go into a case pre-trial, anything through the sentencing phase, is something. I mean, I know the process in my sleep. I've been doing it for almost 20 years, about 18 years now, and so The pre-trial phase is something that I have perfect comfort with. The appellate phase is something that I am very uncomfortable with, as I just don't have any experience with it.
Well, that's okay.
Everything has been screwed up in this appeal. The record wasn't properly certified. When it was certified, it was an incomplete record, or it wasn't properly designated by my office. And then when the record was certified, the record was incomplete, and I didn't know to check it immediately. So it was 2 months later when I realized that, the record hadn't been properly. Then the record needed to be supplemented, and that was 2 days before the opening brief was. Because I wrote the opening brief and went back to refer to the record to make my citations correct, and the record didn't have anything I needed to cite to. So it's one of those things where, I guess here's what I would tell you. If you apply for court-appointed counsel again, okay, for the appeal, they will appoint a public defender from the appellate office down in Denver to represent you, unless there is, for some reason, a conflict with the public defender's office, which is unlikely, that they'd have a conflict with handling the appeal. And the people in the public defender's appellate office, all they do are appeals. So you would have somebody who is in the exact opposite situation that I'm in, which is I never do appeals. My work is all done trial and pre-trial or up through the sentencing process, whereas you'd be represented by somebody whose expertise was solidly on appeals. Okay.
All right.
They have a substantially staffed, a very large, well-staffed office down in Denver. Well, they'd probably tell you they're understaffed, but there's a bunch of them in the public defender appellate office, and they're all based in Denver. And
would I file request for a counsel through the normal office up here?
I don't know. What I would suggest you do is you can file. If you're not convicted, you haven't been sentenced yet, have you? Yeah, because I understand that your sentencing was continued.
Yeah. Which that was my other question, real quick. Was I wanted to see if I could get representation, or at least help through the sentencing phase, to make sure that everything is at least as fair as possible. Up to that extent.
Yeah, and you can, at this point, what you ought to do is,
refile.
right now, go back to the public defender's office and file a request for counsel and fill out an application there. Okay, and say you represent yourself pro se, you now want to be represented by court-appointed counsel for the sentencing phase. Okay, when's your sentencing scheduled for?
2.5 weeks from now.
Okay, do that today. Go right now.
Yeah, that's a really good idea. Might even be able to
talking with. Nobody ever made it sound like you were the guy that hunting down to lock up and throw away the key. Frankly, if they wanted to do that, they would have charged you as a habitual criminal. Okay.
Yeah.
So I don't know that if you went in now and applied for counsel, and the public defender said, "Well, wait a minute, we need a delay so we can kind of read the record and make sure we understand all that's going on before we proceed to sentencing." I don't know that the judge would deny that request.
Yeah.
She may. My understanding is you were scheduled for sentencing. I put it on my calendar. I planned on going, and then they told me that they were continuing that.
Yeah, I got some medical issues. Really bad.
But you would certainly, my understanding, unless your financial situation's changed, you would certainly qualify for court-appointed counsel.
Yeah.
And my understanding, you are living with family, you're homeless.
I'm working through that with my dad, and I am staying at a hotel, actually, now. So I have unadulterated access to food and sleep and everything that's keeping me alive.
I'm running late.
Hey, that's more than I needed, absolutely. Thank you.
My pleasure. And, again, I think one of the reasons why you and I get along so well is that I don't think you think I've ever tried to disrespect your opinion or desire to represent yourself and proceed pro bono. But, one of the things I think that you, number one, I don't think that's a great idea, certainly in a felony case, but that's your choice, that's your right. The second thing is, you shouldn't have given up your right to a jury, okay? A 12-person jury would have been really hard, it would have been harder to convince all 12 people
Unanimously
of this,
it would be a hung jury and so forth.
A 40-year-old judge who's been an assistant for 15 years. By the time you get an assistant for 15 years, people get sick naturally.
Yeah.
So I almost always, literally there are 1 or 2% of the cases where maybe you want to be in front of a judge, And that's only because the circumstances are so heinous that you think only a judge will focus on the facts and not the allegations.
Yeah, exactly. That's kind of why the opposite. That's why I thought against judge.
Yeah, but
They would
your
know the law.
facts.
They don't know the law.
Well, there's nothing about your facts that are heinous. Okay? You know, it's not like
Yeah,
there's not a child victim. I mean,
They
it's
just
nothing
trumped
that's
up a bunch of crap.
inflammatory.
Yeah.
Okay, about your facts. So you would have been better off as a jury.
I imagine it would be probably no go for a new trial unless there's a dispute and all sorts of things. You never know.
Here's what I would tell you. My understanding is you had 2 weeks after the trial to file a motion for a new trial. Okay.
Gotcha.
After that, you're left with the right to an appeal. So if you appeal the case, the Court of Appeals may remand it back to the trial court for another trial.
Or not, but depending on how it is. Yeah.
There's a rule where you can file a motion for a new trial. That's a much more limited, narrowly focused. So
Real quick, last question. Motion to reconsider. Have you ever thought about that, or when does that get filed? Right after the sentence?
well, if you look at that,
Because it's like an easy appeal kind of thing.
well, a motion for reduction, it's what's called 35B, okay? It's under Colorado Rule of Criminal Procedure 35, subparagraph B, okay? So, 35B is motion for reduction. Rule 35 is basically post-conviction relief, okay?
Yeah.
And 35B addresses when the judge sentences you, and you're asking the judge to reduce or reconsider your sentence. So, for example, if Judge Blanco sentences you to prison, you have 126 days, I think, or maybe 125. All the deadlines are now multiples of 7. So you have what would be, I think, 126 days, okay, in which to file a motion on 35B for reconsideration of sentence. So if she sentences you to prison, you have that deadline in which to file a motion to reconsider to get you sentenced to either Concord or probation in lieu of prison. If she sentences you to community corrections instead of probation or prison, you have that same deadline in which to file a reconsideration so she can sentence you to probation. Okay. Now, if she sentences you to either prison, probation, or to community corrections at any time during a community corrections or a probation sentence, you can file to modify the terms and conditions of that sentence. So if you get an 8-year community correction sentence, you can ask at any time, gee, can we consider making this a 4-year sentence? Okay, same with probation. If you get an 8-year sentence to probation, that can be modified at any time to a shorter sentence. Okay, what you can't do outside of that 126 is you can't jump from DOC to Concord to probation, or back, anything like that. So after 126 days, you're stuck where she put you, which is either DOC, Concord, or probation. But if you're in Concord or probation at any time during that sentence, you can petition to modify the conditions of that sentence.
But it wouldn't be a motion to reconsider the actual overturning of the conviction.
It wouldn't be a motion under 35B. If you look at the actual probation statute or the community correction statute, it allows for modification of the term.
Only the sentence. Okay. So an appeal would be the actual overturning. Thank you very much.